Madam President and members of the Court, it is a great honour to appear before you again and a privilege to appear on behalf of the State of Israel. It is my task today to address the issues falling within the general categories of prima facie jurisdiction and the preservation of alleged rights sought to be protected. However, I would like first to make a preliminary comment about the key question of context. It constitutes the framework for the consideration of this request for the grant of provisional measures. South Africa casts its net widely. In its application, it uses the word context many times. In particular, it declares that it is important to place the acts of genocide in the broader context of Israel's conduct towards the Palestinians during its 75-year-long apartheid. Leaving aside the outrageous nature of that statement, why stop at 75 years? Why not refer to 1922 and the approval by the Council of the League of Nations of the British Mandate? Or 1917, the proclamation of the Balfour Declaration? Maybe also include the entry into the land of Israel of the Israelite tribes some 3,500 years ago. No. The immediate and proximate context for the specific allegations of genocide claimed by South Africa lies in the events of the 7th of October, when Hamas militants and other armed groups and individuals stormed into the internationally recognized sovereign territory of Israel and committed acts of barely credible atrocity. It was these events that truly constitute the real context for South Africa's allegations. Indeed, such acts may be seen as the real genocide in this situation. As the President of the European Commission put it on the 19th of October, there was no limit to the blood Hamas terrorists wanted to spill. They went home by home. They burned people alive. They mutilated children and even babies. Why? Because they were Jews. Because they were living in the state of Israel. And Hamas's explicit goal is to eradicate Jewish life from the Holy Land. These terrorists, supported by their friends in Tehran, will never stop. And so Israel has the right to defend itself in line with humanitarian law. Of course, these atrocities do not justify violations of the law in reply, still less genocide. But they do justify, mandate even, the exercise of the legitimate and inherent right of a state to defend itself, as enshrined in the UN Charter and under customary international law, to put an end to the continuing attacks against it and to prevent them from succeeding, a threat that has been made explicitly by Hamas and repeated, and it is thus real and imminent. This context is critical, for it shows that the true nature of the situation as it has unfolded, particularly the 7th of October, is that of an armed conflict. A heavily armed militia and its allies precipitated egregious hostilities, and the consequences lie everywhere. The point is this: armed conflict, even when fully justified and conducted lawfully, is brutal and costs lives. The particular category before this court is genocide. Not every conflict is genocidal. The crime of genocide in international law and under the Genocide Convention in international law is a uniquely malicious manifestation. It stands alone amongst the violations of international law as the epitome and zenith of evil. It has been described correctly as the crime of crimes, the ultimate in wickedness. If claims of genocide were to become the common currency of armed conflict, whenever and wherever that occurred, the essence of this crime would be diluted and lost. I turn now to the question of the prima facie jurisdiction of the court in the matter before us. Here, South Africa cites only a couple of general public statements by Israel, referencing merely a press report by Reuters and a publicity release from the Israeli Ministry of Foreign Affairs. These responses were not addressed directly or even indirectly to South Africa. There is no evidence of positive opposition as required by the court. Further, South Africa cites no relevant exchange between the parties, which would be the normal fashion for the expression and determination of a dispute between states. This actually typifies how South Africa has approached this matter. It seems to believe that it does not take two to tango. It is sufficient if one state determines there is a dispute, leaving the other party flummoxed. Professor Dugard explains that South Africa had voiced its concerns in the Security Council and in public statements and had further referred the matter to the International Criminal Court. At that point, he says, it became clear there was a serious dispute between the two states. The court has emphasised that in the case of statements made by one state in a multilateral forum, the court must give particular attention inter alia to the content of a party statement and to the identity of the intended addressees in order to determine whether that statement, together with any reaction thereto, show that the parties before it held clearly opposite views. South Africa's actions were insufficient, from South Africa's public statements, démarche and referral to the ICC of Israel's genocidal acts, that a dispute existed between the two states. This is not a dispute, it is a unispute, a one-sided clapping of hands. Professor Dugard perhaps tries to retrieve the situation by declaring that special considerations apply to the existence of disputes concerning Article 9, without telling us what those conditions could possibly be. The Prime Minister stands at the head of these organs, decides on the agenda of their meetings, steers their activity, and summarises the meetings and the instructions issued therein. To make it clear, in order to determine the policy and intentions of the government of Israel, it is necessary to examine the decisions of the Ministerial Committee on National Security Affairs and the War Cabinet, and to examine whether the particular comments expressed conform or not with the policies and decisions made. Thus, to produce random quotes that are not in conformity with government policy, produced as describing, is misleading at best. Such as the statement by the Minister of Heritage, for example, who is completely outside the policy and decision-making process in the war. In any event, his statement was immediately repudiated by members of the War Cabinet and other ministers, including the Prime Minister. In tab 1A of the volume which Israel has submitted to the court, one may find numerous excerpts from internal cabinet decisions that attest to Israel's true intent throughout this war. For example, one finds the instructions from the Prime Minister in a meeting of the Ministerial Committee on National Security Affairs from the 29th of October, stating the following. 1. The Prime Minister stated time and again, we must prevent a humanitarian disaster. 2. The Prime Minister indicated the possible sorts of solutions that will ensure required supply of water, food and medicine, increasing the amount of trucks entering with the necessary inspections. 3. Promoting the construction of field hospitals in the south of the Gaza Strip. To re-emphasise, this is a directive to authorities, nothing less. Tab 1A contains a considerable number of similar directives, emphasising the need to avoid harm to civilians and facilitate humanitarian aid. Genocidal intent? Let me turn to the IDF. This, like every army, is a hierarchical body that operates by way of orders from superiors and is headed by the Chief of the General Staff. Remarks or actions of a soldier do not and cannot reflect policy. In tab 1B, one may find a daily operational directive, which I understand is repeated day by day, issued by the Operations Directorate of the IDF, stating that attacks will be solely directed towards military targets, while adhering to the principles of distinction, proportionality, and the obligation taking precautions in attacks in order to reduce collateral damage. This is a directive that binds all IDF forces. It continues by stating that the laws of armed conflict allow destruction to civilian property only when there is a military necessity to do so, and prohibit harm to property for deterrence purposes only or for the purpose of punishment, individual or collective. It emphasises that it is necessary to treat enemy civilians with respect. They should not be treated in a humiliating manner, and civilians should not be used for the purpose of performing activities that might put them under risk to their life or their body. This is a mandatory instruction effective since the start of the war. Tab 1B contains many similar provisions, which are themselves only an illustration of many other such directives, orders and procedures. Further, on the 28th of October, the Prime Minister publicly declared that the IDF is doing everything possible to avoid harming those not involved. But on the 18th of November, he declared that, first of all and above all else, Israel acts according to the laws of war. This is how our army works. The Minister of Defence publicly stated on the 29th of October that we are not fighting the Palestinian multitude and the Palestinian people in Gaza, and declared on the 13th of November that our war is against the Hamas terrorist organisation, not the people of Gaza. Again, the President of Israel declared on the 12th of October that we are working, operating militarily according to rules of international law, period, unequivocally. We have collated numerous such statements by the President, by the Prime Minister, by the Minister of Defence, by the IDF spokesperson and others in tab 2 of our volume. Since this is such a critical part of South Africa's thesis, permit me to refer to two further statements by the Prime Minister. I start with the most recent, 10th of January. Israel has no intention of permanently occupying Gaza or displacing its civilian population. Israel is fighting Hamas terrorists, not the Palestinian population, and we are doing so in full compliance with international law. The IDF is doing its utmost to minimise civilian casualties, while Hamas is doing its utmost to maximise them by using Palestinian civilians as human shields. The IDF urges Palestinian civilians to leave war zones by disseminating leaflets, making phone calls, providing safe passage corridors, while Hamas prevents Palestinians from leaving at gunpoint and often with gunfire. Our goal is to rid Gaza of Hamas terrorists and free our hostages. Once this is achieved, Gaza can be demilitarized and de-radicalized, thereby creating a possibility for a better future for Israel and Palestinians alike. On 23rd of November, Prime Minister Netanyahu declared that any civilian death is a tragedy, anyone, and to avoid them, what you do is first you try and get the civilian out of harm's way, and that's exactly what we did. There are many more of the same. Any careful review of the official and binding policy decisions made by the relevant authorities in Israel since the outbreak of the war clearly evidence that such decisions lack any genocidal intent. The contrary is true. They are indicative of the consistent and relentless commitment of Israeli relevant authorities to mitigate civilian harm and alleviate civilian suffering in Gaza. Some of the comments to which South Africa refers are clearly rhetorical, made in the immediate aftermath of an event which severely traumatized Israel, but which cannot be seen as demanding genocide. They express anguish and the necessity to restore control over Israel's own territory under severe threat and safety to its citizens. As Judge Tomka has noted, sometimes statements are made which are nothing more than a part of the recent wartime rhetoric, intending to put the blame and shame on the other side, not to be totally ignored, but not to be ascribed an importance which belies how and when they were made, nor of legal significance. Let me refer to one further matter of some biblical moment. Yesterday, the applicant referred time and again to two statements by the Israeli Prime Minister where he said, "Remember what Amalek did to you," and attached great importance to it as part of the argument that Israel has demonstrated a genocidal intent. There is no need here for a theological discussion on the meaning of Amalek in Judaism, which was indeed not understood by the applicant. Let me just turn to the Prime Minister's statement of the 28th of October, which was partially and misleadingly quoted yesterday. He said, We are now entering the second phase of the war, which its objectives are clear: destruction of the military and governmental capabilities of Hamas, and the return of the hostages back home. In the last couple of days, I have met with our soldiers in the bases, in the field, in the north and in the south. Remember what Amalek has done to you. We remember and we are fighting. In front of our brave and hero soldiers, there is one prior mission: to defeat the murderous enemy and secure our existence in our land. The IDF is the most moral army in the world. The IDF does everything to avoid harming the uninvolved. Tab 3 lists and addresses additional examples of misleading quotes by the applicants regarding Israel's policy. It is thus our conclusion that South Africa has failed to demonstrate the prima facie jurisdiction of the court.